Good afternoon. Welcome to Division 2 of the Court of Appeals. My name is Judge Furman. This is Judge Daly. This is Judge Lipinski. We have two cases on the 1:30 docket, Whiting-Turner versus Guarantee. I assume counsel are ready on that case?
Yes, Your Honor. Yes, Your Honor.
And then Hiotis versus Board of Education. Are counsel here on that case?
Yes, Your Honor. Yes, Your Honor.
You should have been provided with a handout of our procedures. I assume you have. And you all too? All right. The second case, counsel are directed not to disclose the names of the child that's involved. Of course, we're live streaming these arguments. And if anyone in the courtroom has a cell phone, please make sure it's off and let's get started.
Good afternoon, Your Honors. May it please the court. My name is Corey George, bar number 41058. I have co-counsel Colin Baumschen at the table as well. Here on behalf of the appellant, Guarantee Company of North America, which I may refer to as GCNA, with the court's permission from time to time. I would like to reserve 2 minutes for rebuttal, if I may.
All right.
Some quick facts and some important context I would like to give this court as it considers this appeal. This appeal stems from a privately owned construction project in downtown Denver. On that project, Whiting-Turner was the general contractor. Clemco was the subcontractor. They performed some of the underground garage construction work. The subcontract between Whiting-Turner and Clemco required Clemco to obtain payment and performance bonds. And so this was not a situation where it was mandated by statute or some other law. This was at Whiting-Turner's discretion. They required Clemco to obtain payment and performance bonds, which Clemco did obtain those from GCNA. The bond forms itself were part of the subcontract and had to be in a form that was acceptable to Whiting-Turner. The bond form the performance bond form that's at issue before this court here today is the performance bond. And that bond form is written on an American Institute of Architects, or an AIA A312. And as you may have seen from some of the briefing and the record, that is an industry standard bond form that is used in Colorado and having seen decisions in other jurisdictions. That's a bond form that's used across the country, and there are a number of decisions interpreting that specific bond form or one nearly identical to it. And so that's important from the appellant's perspective, because that specific bond form is what we're ruling on here today. As you know, quick thing on surety law. In a performance bond, you have a tripartite relationship where you have a surety that issues the bond. It has an obligee. In this instance, that was Whiting-Turner. And it has a principal, in this instance, that was Clemco. The surety has to balance those conflicting duties and competing duties in that tripartite relationship because it owes duties and obligations to both of those parties. The AIA, there are many different bond forms, but the AIA A312 that's before this court addresses those competing interests in a manner and in a way we would submit to you that sureties rely upon and the parties who use that bond rely upon, because it is an industry standard form, so they come to expect the guidance that is out there and the reliability that that specific bond form has. I tell you all that to say This is an appeal about a case from a construction project in Denver, but this AIA A312 bond form has serious implications for the surety industry that are far-reaching beyond this one project. And so that's the context that I was hoping. I'd like to give you a quick roadmap of the arguments I'd like to present to you here today. The first one is that the district court erred in interpreting what is required by section 3.3 of that performance bond, that A312 that I just referenced to you, in two ways. First, in terms of what is required by that condition precedent that's listed in section 3.3, and also in terms of the court's finding that Whiting-Turner complied with that condition, 3.3.
Counsel, do we need to get into these if we were to conclude that a waiver had occurred here? A waiver of requiring them to comply with 3.3?
No, Your Honor. I mean, if this panel finds that GCNA waived or that Whiting-Turner was otherwise excused from complying with those conditions, then I think an honest answer to that would be no. Obviously, as you might imagine, one of the other arguments I intend to present to this court is that the district court erred in finding that there was a waiver or that GCNA was stopped from asserting compliance with those conditions, namely 3.3.
Why don't you present that argument now?
Be happy to.
Thank you.
With respect to the waiver issue, the judge's conclusion from the order on this is confined into one sentence and contains no specific reference to the record or to any supporting law from GCNA's perspective.
Mr. George, is there any indication in the record why GCNA didn't respond to Whiting-Turner's letters? There's no dispute that Whiting-Turner sent a number of letters to GCNA. Does the record inform us as to why GCNA didn't respond to that correspondence?
There's not an affirmative act. There is in the record, Judge Lipinski, a letter that was from Clemco at the critical time period of May 30th that Clemco responds back to Whiting-Turner on behalf of itself and GCNA, specifically referencing and intending to enforce Section 3.3 of the bond. The other, to answer your question, if I may, Judge Lipinski, is part of our argument is, even if you look at the timetable of this, there's three different conditions that have to be met in Section 3 of this A312 bond. The first one is a notice of intent. The second one is that there's a declaration of default and a termination. The third one is this issue in 3.3 of the timing and the tender of the balance of the subcontract. That's the one we're here before. The other two are not in play here. That's the one. But if you look at the timing of those issues, even the district court found that the subcontract balance did not turn negative until June 17th, and the district court found that the GCNA's obligations under the A312 bond arose as of June 24th. This is all 2014. And so if the district court's conclusion that a series of emails and phone calls or letters that if left unresponded to by a surety is tantamount to a waiver, there would be chaos with respect to this form in the surety industry, because here's why. The surety there's no law out there that we're aware of, and there's law to the contrary, that says a surety has an affirmative duty to respond. It's still, until its bond obligations are triggered, it's still in this tripartite relationship between its principal, who's still doing the best it can to finish this job, and the obligee.
But there was correspondence from Whiting Turner asking GCNA, what do you want us to do? And as far as I can tell, GCNA's response was silence. Is that a correct reading of the record?
That's a fair reading of the record prior to June 24th. And so what you would have to hold is that a principal who sends an email or a letter to a surety saying, what would you like us to do, stands in the place of complying with the specific conditions precedent set forth in Section 3 of that bond. And so you have situations in other cases that we've cited for this court where sureties have went to the meeting that's set forth in Section 3. They've hired investigators and consultants to oversee construction.
Mr. George, I'm sorry to interrupt, but
You're-
your time is moving quickly here. I wanted to get into the substance. The balance of the contract price
Yes,
seems
sir.
to be the focus of the substance. So, opposing counsel points out that the balance it points out the language, including any changes made to that agreement, and after all proper adjustments. Those are the two key terms to me. And so a meeting was held April 30th, where there appeared to be a change to the agreement as far as the shotcrete, for example. So could you address that?
Yes. You're referring to Section 14.1, which
Correct.
contains the definition of the balance of the contract price in the bond. From GCNA's perspective, that talks about proper adjustments is part of the language there. At no point in time, for any of the amounts that we're talking about that are relevant to the contract balance that's at issue on this appeal, was there a change order put forth by Whiting Turner? The
Why was a
record,
change order necessary?
Right.
Because at the meeting on April 30th, and this is a finding of fact of the trial court, I believe, GCNA was present. Whiting, Turner, and Klemko agreed to reduce the balance by the 553,707, and GCNA didn't object.
at that time of the April 30th meeting, GCNA's obligations under the bond had not been triggered.
Okay, that's not the point. What the point is, could those two parties to the contract agree to that change, where Whiting Turner would take over the work?
There's no doubt that Whiting, Turner, and Klemko could have agreed to a change in the contract.
Is that what happened on April 30th?
No, and
Okay.
I think that the reason, there were discussions about that and what would happen with that scope of work. From GCNA's perspective, that never gets memorialized in a change order, which we think is important, but even more than that, those dollars are prospective. And if you read the case law that GCNA cites relative to the section 3.3, it talks about payments made, right? And so the record is clear. We jumped into the waiver, so I skipped over part of the second argument, which relates to the timing, which I think is important here.
But in those cases, I know we're running short on time, in those cases, hadn't the general contractor brought in a substitute subcontractor? As opposed to the situation here where there was no new subcontractor in place.
On some of those cases, it's true where they paid money, whether it's a replacement subcontractor or it's somebody from the existing project, is not a meaningful distinction in terms of our perspective, in terms of the definition of the balance of the contract price. A payment made, whether to a replacement subcontractor for which bids were taken or they were found another way, or from somebody else, from our vantage point, it talks about 14.1, payments are either made or they're not. And the cases also say that forecasted payments do not count in terms of reducing that contract balance amount. And the key thing from GCNA's perspective is if you adopt in a case of, I think, first impression in Colorado law on section 3.3, what's the timing required of this offer of the tender? And essentially, the district court found that whenever it was made, that was good. And the East 49th Street and a number of other cases all consistently hold that the timing of that tender has to be made at the time of the termination or at the time of the declaration of default.
But didn't Whiting Turner make a tender, but at the same time indicate that there was nothing left in the balance of the contract price?
Yes, and if I may briefly talk about that, the timing of that is important because from GCNA's perspective, the date of the declaration of default is on April 28th. The date of the termination is on May 22nd. Those facts are not in dispute. There's no tender as of that date. And that's part of our argument to this court to align themselves with the other jurisdictions that have interpreted this provision. And that is the timing of that tender has to be made then. There's no dispute, at least from our perspective, and the record is replete with examples of Whiting Turner saying at that point in time, the contract balance is positive. Even the district court found that the subcontract balance didn't turn negative until June something. GCNA disagrees with that, even that finding, because we say that $550 from the April 30th meeting, those were dollars that were not paid, didn't get reflected in a change order, and there's evidence to the contrary from Clemco on the nature of that.
So, Mr. George, I see that you are out of time.
I will reserve my other 2 minutes, thank you.
You ran out of time.
That's the total time?
Yeah, that's the total time. Is that right? Yeah.
I apologize, Your Honor, I clicked over. May I have 30 seconds to conclude?
Yeah, I'll give you an extra 30 seconds to conclude, and then I'll give you some additional time too.
Thank you, Your Honor. I just wanted to say, for all those reasons and the reasons in our brief, we'd request that this court reverse the decision of the district court with respect to Whiting Turner's payment bond claim. We didn't get into the argument, but for the same reasons, the attorney fees finding would also fail. Thank you.
Okay, thank you.
Good afternoon. May it please the court. My name is Jeff Whitney, and I represent the Whiting Turner Contracting Company. The district court below found that GCNA breached both the payment bond and the performance bond. It's important to note that GCNA has only appealed the lower court's ruling with respect to the performance bond, not the payment bond. In connection with that, they've also appealed the award of attorney's fees. We're here today to ask this court to affirm the lower court's decision that GCNA breached the performance bond and affirm the lower court's decision to award Whiting Turner its attorney's fees and costs, as well as an award of attorney's fees for this appeal. I'd like to start where opposing counsel left off, and that is with the balance of the contract price. GCNA has argued that the balance of the contract price is measured at the time of default and/or termination, and thus must be tendered at that time. However, there's no such requirement that the balance of the contract price be measured on the date of default or termination. No such requirement in existing case law, no such requirement in the performance bond itself. The cases cited by GCNA in its appellate briefs merely hold that the contract price cannot be reduced with payments to replacement contractors, payments for remedial work, payments not authorized by the underlying construction contract, or by payments that were not actually made. Those holdings come from the LaSalle Group case, the East 49th Street case, and the Stonington case. In this case, there's evidence in the record to demonstrate quite clearly that the balance of the contract price was not reduced with any such payments. It wasn't reduced with payments to replacement contractors, payments for remedial work, or payments that weren't authorized under the contract itself.
What is, when Whiting Turner steps in, is it not itself a replacement contractor?
No, Whiting Turner did not hire itself to complete Clemco's scope of work.
Who did it hire? Is that a replacement contractor?
No, the people that were completing Clemco's scope of work were simply people that were already on the job itself. But there's a distinction between people that actually finished this scope of work, because the project did go on and wasn't complete at the time that Clemco walked, and the payments that were used to reduce the balance of the subcontract price itself. Now, the only payments that were made to reduce the balance of the subcontract itself were payments to Clemco's vendors who had already performed work on the project prior to Clemco's termination, who Clemco confirmed were in fact owed money, as well as the amounts of money that was owed.
But that, sorry to interrupt, but that didn't involve the shotcrete.
Yeah, I'm interested right now how we treat the 553 grand.
Yes, that is treated differently than payments to reduce the balance of the subcontract price. As you know, under the bond itself, it says that what you start with is the total amount payable by Whiting Turner to Clemco under the subcontract. Now, in order to figure out what the total amount payable by Whiting Turner to Clemco under the subcontract, you've got to figure out what they're owed. That amount went down when that work, the shotcrete work, was removed from the contract itself pursuant.
It was backed out of the contract, is what you're saying.
Correct, Your Honor. So
Did the subcontract require a change order effectively to reduce the amount payable to Clemco?
it did not, and there's no finding by the trial court that a change order was required by that. It was simply an agreement of the parties during an April 30th meeting at which GCNA itself was present, that was later confirmed in writing, including in a letter to GCNA, an email to GCNA, in which Whiting Turner said, "Are you on board with this?" GCNA did respond to that and said, okay. So in order to get to what the balance of the subcontract price is, we look to the bond itself. The bond says you start with the amount that's payable to Clemco by Whiting Turner. To get to that amount, you've got to back out what the parties agreed to remove to the contract, from the contract. That's the $553,000 and change. You also then have to subtract, according to the language of the bond itself, reduced by all valid and proper payments made to or on behalf of Clemco under the subcontract. So the next step is we back out the payments that were made to Clemco's unpaid vendors that actually performed work on the project prior to termination, and who Clemco confirmed were in fact owed those amounts of money.
So, Mr. Whitney, I'm confused. The 553,000 adjusted, or however that happened, the work still had to be done. So who did the work?
Correct. That work was done by Clemco's subcontractors and vendors.
Okay, but so that they had to be paid
Correct. Whiting
Where-
Turner made those payments
later.
later. Those payments are not payments we're using to reduce the balance of the subcontract price. Those are payments, however, that are included in the total amount of damages for which the court found Clemco was liable for its breach of the contract, and that GCNA was liable for as the guarantor or the surety.
Why is Clemco liable for it? If basically you reduced it out of the contract, it's no longer part of the contract, why is Clemco liable for it?
Because-
You know, if they would have paid the same money to Clemco as they paid the 553 to somebody else, why are they liable?
Because that work wasn't able to be performed for the 553. It ended up costing more. And it's
And the more, I would think, would be damages, but why is the 553 damages?
the 553 itself is damages because it was all paid. That was all money that was paid. So to the extent every dollar from that 553 was over the amount for which Whiting Turner hired Clemco to complete this total scope of work, it would be damages. But in this case, I'm arguing, and the court found, that 553 is used to, in calculating the balance of the subcontract price, that amount itself is removed at the very start of that calculation.
But later paid anyway. I mean, more than that.
At some point, yes, Clemco ended up paying that money to those vendors, Whiting Turner ended up paying that money to those vendors and subcontractors who actually performed that work.
Clemco was gone by the time that money was paid.
Yes, correct. At the time Clemco abandoned the project, there was $553,000 and change left within the subcontract for that specific work.
Did
The
the insurance company independently appeal on appeal the amount of damages awarded if it included these $553,000?
They did not.
I'd like to talk about the back charge for a moment. So the back charge was $31,623 and a few pennies. The trial court didn't reduce the balance of the contract price by that amount, even though it held that Whiting Turner couldn't recover the amount of the back charge as part of its damages in this case. Is that inconsistent? Is there an inconsistency?
No, it's not.
And why not?
The reason is, while that amount was pulled out of the damages that Whiting Turner was ultimately awarded from both Clemco and GCNA, that amount itself was not used to calculate what the balance of the subcontract price is. So we're talking about two separate calculations. We're talking about, in one case, a damages calculation that's required by contract law. And in the other case, we're talking about a calculation of a defined term, balance of the subcontract price. And that math was done according to the performance bond, which says, here's exactly how you measure that. Included in that math, in the math that determined the balance of the subcontract price, this $31,000 and change that you're referring to was not included whatsoever in that math. We still, however, get to a negative contract balance. The reason we get there, the math is quite simple, is we start with the contract amount that the party stipulated to, which was roughly $1.785 million. We also then subtract out $1,064,929. Those are payments, pre-termination payments that Whiting Turner made to Clemco. That amount is not in dispute. Then we remove from the contract the agreed upon amount that the parties agreed to pull out of the contract, $553,707. And then finally, we subtract, because that's what the definition of balance of the contract price allows us to do, is subtract payments made to or on behalf of Clemco. These payments to Clemco's vendors were made on behalf of Clemco. That's an additional $256,897. That math gets you to a negative balance of the contract price. And I will point out too, I think that looking to just the bond itself, the performance bond itself, when figuring out, is there a certain time that this calculation has to be made? Is there a certain time that this tender has to be made? The case law doesn't indicate so. The bond itself doesn't indicate so. But what the bond does is it protects the surety by saying, here's how you make that calculation. And it tells you exactly what payments need to come out of that. Now, that calculation and that definition doesn't allow for Whiting Turner to go out and hire a replacement contractor. It wouldn't allow for Whiting Turner to pay unilaterally for any kind of remedial work. It wouldn't allow Whiting Turner to subtract payments that it didn't actually make. But none of that occurred here, based on the court's finding. It only subtracted payments and reduced the balance by things that were called out specifically in the performance bond's definition. I'd like to also address briefly the waiver finding by the trial court. First, we don't think the court needs to get to a decision on waiver because as the trial court found, Whiting Turner did in fact comply with section 3.3 of the performance bond. That ends the inquiry in itself.
Let's talk about compliance for a moment. At one point, in the context of the payment bond, the trial court stated that Whiting Turner didn't need to substantially comply with the terms of the payment bond. Isn't that an inaccurate statement? And is that something we should address if so?
It is not something that this court needs to address. That is a statement that the court made in connection with the payment bond only, in a section of its findings of fact that occurred after all of its rulings and holdings with respect to the performance bond itself.
But would you agree it's an incorrect statement of the law?
I would not agree that it's an incorrect statement of law. First of all, I don't think the court needs to get to it. But secondly, if the court does need to address whether substantial compliance is enough or whether strict compliance is required, there is no Colorado case law that says when we're talking about bond conditions that strict compliance is required with those. In fact, the only law cited by the other side comes from different courts, not Colorado. The only Colorado case law cited talks about strict compliance being required to satisfy conditions precedent. But that deals with specific types of contracts. The one case dealt with a contract to buy and sell real estate. The other case dealt with a contract, an option contract, exercising an option. Those cases don't deal with bond requirements as we're dealing with here.
Why should condition precedent law be treated differently in this context as opposed to the other ones?
There's also no holding in Colorado that these bond...
Why should they be treated differently than the condition precedent holdings in the other cases?
Two reasons. First of all, I don't concede that these are conditions precedent. There's no Colorado case law that says that these bond requirements are conditions precedent. And if you look at the cases from around the country, there's a split of authority on that. The International Fidelity v. County of Rockland case held, and this is cited in the brief, that Section 3 of this bond aren't conditions precedent. Also, if you look to then Colorado law, not dealing with bond conditions, but dealing with dealing with bond conditions, you've got the Brighton School District case that itself holds that notice obligations are in bonds and construction contracts that then are incorporated into the bond itself, that there was sufficient notice, the court said. That's different than strict compliance. Also, if you look at the Riva Ridge case, in that case, the court did enforce a bond, finding that the owner in that case or the general contractor substantially performed the conditions. So I don't think there is established Colorado case law that says these Section 3 requirements are conditions precedent, nor do I think there's any Colorado case law that says when we're dealing with bond requirements, strict compliance is required. In fact, I think the Brighton School District and Riva Ridge case say otherwise.
Were both of those cases notice provision cases?
The Brighton School District case was a notice provision case, and the Riva Ridge case, I don't know which part of Section 3 it was specifically referring to, but the court said that not only was substantial performance enough, but the court also said that the surety must be damaged by any deviation from the terms of the contract itself in order to be relieved of its obligations.
So I said I would give you another 15, well, now you're 20 seconds if you have any last comments.
My only last comment is, for those reasons, we ask that the court affirm the decision of the trial court below and award Whiting Turner its attorney's fees in connection with this appeal. Thank you.
All right, thank you, counsel, for your excellent arguments. The case will stand submitted and a written opinion will issue in due course. Whenever you're ready.
Good afternoon, Your Honors. My name is Brooke Copus, registration number 45045. I represent the appellant, Charmin Hayotis. This involves the attempt of the Colorado State Board of Education to deny Ms. Hayotis' professional teaching license renewal application. While the board embodies the state's legitimate interest in protecting the school community for harm, in this case, the board is attempting to extend its reach beyond the classroom and the school community and into the private and personal life of an excellent teacher. While Ms. Hayotis contends a number of factual and legal issues on this appeal, this case must be overturned because the only basis in which the board found a nexus between Ms. Hayotis' conduct and her fitness to teach was based on the incorrect interpretation of Colorado's mandatory reporting statute. There's no dispute that Ms. Hayotis is a teacher, and in that capacity as a teacher, she has a legal duty to report child abuse or suspected child abuse.
Would she have had a duty to report the child abuse if her daughter had also been her pupil?
So that's a good question, because I think that came up in the hearing. No, and this is why. She learned of the abuse as a parent. This had to do with something within her family, the abuse of her then husband, no longer husband, Mr. Peterson, on the child. So she learned of it in that capacity. And in that capacity, yes.
Sorry to interrupt. What language in 193304 restricts the reporting duties to just inside the school setting?
So the statute itself doesn't explicitly state that. Instead, I would say that the language that shows that is the fact that it lists professions. That in and of itself shows that it was meant to include those who are working in those professions and learn of that abuse in that capacity. There's no language in the statute that this duty extends beyond the profession and into the home life or into the
But for one
societal life.
category, the statute does contain that exception, which is the category of the commercial film and photographic print processors.
Right, and go ahead. So I don't think our contention is that the fact that it says that doesn't change this analysis for a couple of reasons. First, the purpose of Section 2.5 of the statute is to limit the reporting requirements of these processors in the fact that they have to keep the photograph or keep the film that they find so that there's a chain of custody, but also that they have to make this report. The second part about this section is it says, within the scope of his or her professional capacity of employment, and it relates back to the fact that this is for commercial processors, and I'll just use the word processor to kind of incorporate that entire sentence. Unlike the rest of the professions listed, an individual can be engaged in the processing of film and photographs, not in a for-profit or occupational setting. In fact, it's a hobby. And I think this is better evidenced when you look at another part of this section, which is 304(2)II, which states that a director, coach, assistant coach, anyone employed by a private sports organization or program. It excludes those who coach sporting events as a hobby. Lastly, interpreting the statute to say that just print processors, this is the only profession that's required to report only in the official capacity, implicates equal protection issues. And this court and any court cannot read a statute in a manner that would render it unconstitutional.
Did you argue the equal protection issues in your brief or even in the proceedings below?
It was mentioned in our reply brief in response to the board's contention that this one provision of the statute renders it that, it's outside of the capacity as well. And so we didn't make the argument that it would violate equal protection. We made the argument that it would implicate a potential violation of equal protection.
Did you make that argument in the proceedings below?
No, this provision didn't come up in the proceedings below.
193304 wasn't?
The 2.5 where it had to do with the print processors, it was never an
Right.
argument.
But the interpretation of the statute was?
Correct, yes.
Okay.
So let me read an introductory provision, 193302. The General Assembly declares that the complete reporting of child abuse is a matter of public concern and that in enacting this Part 3, it is the intent of the General Assembly to protect the best interests of children of this state and to offer protective services in order to prevent any further harm to a child suffering from abuse. Do you think that teachers have a moral responsibility to protect children by reporting?
I think they have a moral responsibility to protect their students, yes.
I said children. This uses the word children.
I would say that if the child is one of their students, then yes. Or a student in the school, that they work in that school community.
Do you think apart from the statute, teachers have a moral responsibility to protect their own children?
I think at that point, you're kind of treading on a interrelationship, interpersonal moral guide rather than what we hold our teachers to. I think the same question would be is if you had a parent who learned of child abuse who is not a listed profession, they would not be legally and criminally bound to report that abuse.
They might be charged with child abuse or child neglect as well for not having reported that.
Right, I understand that's not, I understand that is a possibility for a DA to do, but they wouldn't be able to charge them with a violation of the mandatory reporting statute, which is the.
And that's what I'm asking is, apart from the statute, do you think teachers have a moral obligation to report or to do something about the abuse of their children, their own children?
I think that's a personal question for each individual person. I don't think that I can answer that for any other individual.
Well, if the standard is offending the morals of the community, it might be even a parent would be offending the morals of the community if they weren't protecting their child. This is saying, well, what about this particular parent who happens to be a teacher? That could not be decided independent of the reporting statute itself.
I think it could be determined independent of the reporting statute itself. I think the question here, though, is that that's the basis of which the board is seeking to deny Ms. Ayotis' license. It's that particular statute. There's no other reason that they've stated, that the ALJ stated, that the board stated, or that the district court upheld. The only reason there was a nexus was because this statute, she had a mandatory requirement to report this abuse.
Is it your argument that Ms. Ayotis didn't have an obligation to report the abuse of any child who is not her own biological child?
No, I don't. Repeat that question for me.
Sure. Did Ms. Ayotis have an obligation to report the abuse of any child who is not her pupil?
No.
So if her ex-husband had abused a child as part of the piano lessons, Ms. Ayotis would not have had an obligation to report that?
If it was not one of her students, no. Not under the reporting statute, no. Again, I think the issue was brought up about the child abuse, but I would say under the reporting statute, no, she would not have, our position is that she would not have that legal duty.
Well, then, do you believe that 193304 reflects a moral standard of the community?
I think moral in the fact that if an individual learns of abuse in their capacity, in that capacity of that profession and do not report it, then yes. And if you don't have any other questions on the reporting statute, I'm happy to answer because I think this is extremely important. I don't think, if you could look at the other factors to look at too when you talk about a nexus, none of those factors are here either. I think it's important for this court to understand that this is a teacher who has been until our petition to stay before this court was not granted. Ms. Ayotis had been teaching in the classroom since 1997. Meaning throughout the entire pendency of what was going on with her ex-husband, throughout the pendency of subsequent legal issues, and throughout this entire process, she continued to teach in the classroom and was highly effective. We actually had two of her principals, the individuals who were there on the ground level with her, working with her every day, say, we want her in the classroom. We have no concern for her to be in the classroom, and we have no concern that she would never not report.
Do you agree that they also testified that they believed she had a duty to report this?
I don't recall that specific testimony being advanced. I think the question was whether teachers have a mandatory duty to report. And then in addition, the question was whether, they think she should have reported. It wasn't really a question of, did she have the legal duty?
And what was the answer to they think?
My understanding from my recollection from all the testimony is that, right, they believe that she should have reported it. But they also testified, and this includes our other witnesses as well, including members of the community and fellow teachers who stated, we understood that there were other factors going on. And so that takes us to the battered women syndrome factual issue of this case.
And in fact, I'm sorry, in fact, the ALJ and the board made a finding of fact that Ms. Hiotis was not subject to battered women syndrome. And aren't we bound by that finding?
No. So the decision by both the ALJ and the board, there's no explicit finding whether she suffered from battered women syndrome or not. It's couched in, this wasn't the reason for her not supporting. And so the factual findings do support that she was suffering from battered women syndrome. And we had an expert who the ALJ and the board upheld as testifying credibly about the symptoms and causes. All of those symptoms and causes, including the controlling, the social isolation, were all found undisputed that she suffered from that.
And so, sorry to interrupt, did that expert also testify about her reporting duties?
Yes. So it turns out that Dr. Jens was actually also had worked at some time as a school psychologist or school counselor. And there was testimony about how she told teachers about their legal duty to report. And the specific question was, have you ever told, like part of the training, do you tell these teachers that they have to report when they learn of this abuse outside of the profession? And her answer was that no, that's not something that she, taught the teachers at the schools that she worked at.
Was she asked if she told the teachers that they only had to report if they learned about it in their school duties?
The question was not couched that way. No, it was more, did you present to them this factor, or that they had to do it in this aspect?
So I wanted to back up a little bit. You've used the term nexus repeatedly.
Mm-hmm.
Is there something, does that term appear in the board rules anywhere?
No, it does not. The nexus requirement comes from Colorado case law, and that's the Wiseman versus Board of Education of Jefferson County School District that is cited throughout our briefs. So that case was a teacher dismissal case, which is obviously a little bit different than a licensing case. The issue in that case was they were attempting to dismiss the teacher for immoral conduct, the same basis that this unethical behavior standard is. It defines immoral conduct as conduct that offends members of the community. And so Wiseman stated that there had to be some sort of connexus between the fitness to teach and the actual conduct. And in doing so, they cited a licensing case out of Iowa. And so this case has been upheld as finding that there has to be this sort of nexus. If there's not, then the teacher is merely being subjected to discipline for things that happen in their personal life and have no effect on their teaching, which is the legitimate interest of a school board or the Board of Education is to protect the students that the teachers actually teach.
Is it immoral for a school teacher not to report the abuse of a child, even if that child is not his or her own child?
I don't think it connects to the teaching aspect of it. So even if a court were to find, or this court were to find that conduct was immoral, it didn't relate to her fitness to teach. It had no bearing on her classroom, didn't deal with anyone in the classroom, whether that be students or teachers.
But would you concede that the failure to report would be immoral?
I don't think it would be illegal.
I'm asking not whether it's immoral.
Again, I think that's a personal, whether I think it's immoral might be different from whether a principal thinks it's immoral or whether this court member would think it's immoral. So I don't know that I can answer that question. I think it's important, though, to take a look at the factors that contributed to it, including the extreme controlling by this then husband. I mean, him and the daughter, who clearly was also abused by this man, begged her not to report this abuse.
If Ms. Hiotis had failed to report abuse of her child because of the repercussions of being a battered spouse, a battered woman, would she be subject to the reporting requirement nonetheless?
Legally, no. But I guess the question is, it relates back to the underlying causes for it. And so if in order to see if it's immoral, I think we need to look at the context of it. I mean, this is a woman who was being abused by her husband. Whether or not it's immoral for her to do it for a normal person, I think it would be different than someone in that situation.
Are you saying there's an exception in the statute if a teacher suffers from battered women syndrome?
No. And I think
And are
that's.
you aware, I'm sorry to interrupt, we're getting close on time. Are you aware of any case law or other authority that allows battered women syndrome as a defense or as a justification for not reporting?
I don't know that, I'm not aware of any case law. There was testimony about it from the social worker that testified for the board. She testified that, as part of their duties, they were looking into whether to criminally charge Ms. Heotis. And one of the things they said they look at in these cases is whether or not there was domestic violence, and that can have effect on whether or not they're actually charged. But I'm not aware of case law.
Okay, thank you. I see that you are out of time.
Okay, thank you, Your Honors.
May it please the court. My name is Jenna Zarelnik, bar number 42553, representing the Colorado State Board of Education. The State Board respectfully asks this court to affirm the decisions below from an ALJ, the State Board, and the Denver District Court, all of which determined that denial of Ms. Heotis' renewal application was warranted. I plan to focus on 3 reasons the State Board's order should be affirmed. First, the Educator Licensing Act does not deprive renewal applicants of due process because there's no due process right to a certain progressive discipline scheme. Second, the State Board denied Ms. Heotis' renewal application for unethical behavior, not for violation of the mandatory reporting statute. As a result, this court does not have to decide whether she was covered by the mandatory reporting statute. And third, there isn't...
Excuse me, counsel. The order was not premised upon a finding that she had violated the mandatory reporting statute? Is that what you're saying?
Yes, Your Honor. The State Board's order did discuss the mandatory reporting statute, but it wasn't the sole basis for the decision.
What was the other basis besides that? What other conduct was violative of the morals and offense of the community?
On page 8 of the State Board's order, the State Board concluded that there is ample support in the record for the ALJ's conclusion that respondent's failure to report the sexual abuse of her daughter, which placed both her daughter and other children at risk, was connected to respondent's fitness to teach. And the ALJ's factual findings focused on the decision not to report as well as the harm that it caused to the children who were taking piano lessons. So it wasn't, the basis for the order was not a criminal offense. It was the conduct in and of itself, which was unethical.
Is it your position that 193304 reflects a moral standard of the community?
Yes, because it was enumerated by the General Assembly. I do think that interpretation makes sense. The third issue that I'd like to address is that there is a nexus between Ms. Heotis' conduct and her fitness to teach because the conduct harmed and endangered children. Heotis' due process argument relies on her claim that licensees have a vested right to renewal of a license. The Colorado Supreme Court has held that a license renewal's applicant right to a hearing is statutorily based, and the fact that the General Assembly has created a right to such a hearing does not mean that the plaintiffs are independently entitled to it as a matter of constitutional law. In the reply brief, Heotis argues that the Educator Licensing Act contains entitlement language, which creates a property right. The Johnson case, which she cites in support of her entitlement language argument, is not applicable here. It's an employment law case about teacher tenure, and the crux of the court's analysis was the concept of tenure, which by its nature engenders a reasonable and objective expectancy of continued employment. By contrast, the Educator Licensing Act does not use the word tenure or any comparable language, which in and of itself would engender an expectancy of continued licensure. To the contrary, the Educator Licensing Act provides that a teaching license is valid for 5 years and thereafter it may be renewed upon submission of evidence satisfying all the requirements in the law. So there's an expiration date and there's a contingency here for the license. The license may be renewed if within the state board's discretion, the applicant satisfies all the requirements in law. In other words, educators have to reprove their fitness every time they apply. This differs from other professions such as the practice of law, where we merely submit fees in a form every year to maintain licensure. Even if we do assume that HEODIS has an entitlement to renewal based on constitutional law, there's still no statutory or constitutional right to a progressive discipline scheme. Different licensing acts contain different disciplinary options, and this makes sense because due process is a flexible standard. There's a practical problem with comparing the available sanctions in different licensing acts because each act has different grounds for discipline. For example, the Dental Practice Act allows for censure as a form of discipline. One of the grounds for discipline under the Dental Practice Act is allowing liability insurance to lapse. So say that a dentist's coverage lapsed for one day. This could be an appropriate situation for censure, but it probably wouldn't warrant revocation of the dentist's license. By contrast, all of the grounds for discipline under the Educator Licensing Act are more serious infractions that would warrant denial, suspension, or revocation of a license. The General Assembly has decided that the conduct called out by the Act reflects on a person's fitness to teach and warrants action against a license. The Educator Licensing Act doesn't cover personal shortcomings, minor misconduct comparable to an accidental lapse of insurance just wouldn't rise to the level of any discipline under our act.
I'm sorry to interrupt. Do you agree with Ms. Kopis that there is a nexus or that there's not a nexus requirement stated in the rules? Because you're using nexus, as was she, and so I'm wondering.
Sure. I agree that there's no explicit nexus requirement in the Act or the state board rules, but I also agree that the Weissman case doesn't directly apply here because that was a teacher dismissal case and we're trying to construe the Licensure Act today. But if we applied the same analysis in Weissman to provide a due process standard, essentially, that there does need to be at least an implicit nexus, that would make sense.
So it's your position that the nexus satisfies due process, and without it, no due process?
In this case, we don't have the same due process concerns as the Weissman case because we have a state board rule that further defines the term unethical behavior. Whereas in Weissman, the statute at issue just used the term immorality, and there was no state board rule providing a further standard or a further definition. So we still have due process from the state board rule in setting a standard.
Is the standard the same in either case? Immorality by statute, immorality by rule?
No, I don't think the standard is the same because there's not the same state board rule that sets out 11 detailed categories of what qualifies as unethical behavior. And our state board rule in the licensing context also has a floor in terms of severity of the conduct. It has to be substantial or continued, and that's also not present in the Weissman case.
I'd like you, if you would, to address Ms. Kopis' other argument. What language in 19.3.304 doesn't or does restrict the reporting duties to inside the school setting? You could address that.
Yes. Our position is that the plain language of the statute does limit, So for the plain language of the mandatory reporting statute, there are a few reasons. The title of the statute, as well as the introductory paragraph, concerns any person. So it's not the statute isn't only discussing these professionals by their profession. The title and the introduction is talking about any person. And the next reason is that the statute doesn't limit the reporting duty to the course and scope of employment. As mentioned, there is a subsection of that statute which does limit the reporting duty to the course and scope of employment.
Let me ask you this, counsel. Did you cite in your brief cases from other jurisdictions that reached the result that you're proposing here based on the same types of consideration, like, hey, there's no language in the statute about, you know, your occupation or your work?
I don't believe we cited any cases in the brief, no. I have an example of a statute that does have some limiting language about the course and scope.
And that helps because it's more explicit, but I'm not sure it necessarily answers the question we have today without the language.
And could you address the Delaware and Washington statutes cited in the opening brief, the James Buell case and the Gillespie case? Didn't those cases involve statutes similar to the Colorado statute that didn't have a carve-out for the children of school teachers, yet the court did find an exception in those statutes if the alleged abuse involves a child or a grandchild of the teacher?
Was the first case you asked about State versus Hill?
No, the cases were cited in the opening brief. There's a Delaware State case and a Washington case, the James Buell case and the Gillespie case. They were cited in the opening brief but not the answer brief. But it struck me that in both of those cases, the state courts looked at general reporting statutes and created a carve-out where the abuse involved the child or the grandchild of the teacher identified in the statute.
For both of those cases, I think it would be problematic to rely on them because they're out-of-state cases and they're construing and interpreting mandatory reporting statutes that use different language than the Colorado mandatory reporting statute.
How is the language different?
In the Delaware case, the mandatory reporting statute was much more narrow in scope than Colorado's. It only referred to medical service providers, and Delaware subsequently expanded that statute to include all people.
But at the time, it was only at the time of the facts underlying the case, it only applied to the medical professionals, right?
That's correct.
And the case involved a medical professional.
That's correct.
And the court nonetheless created a carve-out for the children or grandchildren of the medical professional.
The court did, but part of the court's analysis was looking at the subsequent version of the statute, which had been expanded to include all people, and that was part of their analysis. Colorado doesn't have a narrow mandatory reporting statute similar to theirs. Ours covers a wide variety of professions, including medical professionals, teachers, clergy, film processors, so I think it's distinguishable in that way.
And how is the Washington statute different from the Colorado statute?
The Washington court found that the plain language did not create an unlimited and unqualified duty because the statute referred to people by means of their occupation, not simply as adults or persons. And the Colorado statute doesn't simply refer to people as persons, but the word person is prevalent in the Colorado statute. It's in the title, it's in the introductory language. So I think that's one difference between the underlying statutes in that case.
Is it a persuasive difference? If so, why?
I think that titling the statute as persons required to report says something about the duty that the court was trying to impose, especially coupled with the lack of course and scope of employment language. There's truly no carve-out here for people acting within the duty of their profession.
But isn't the reference to persons simply a cross-reference to the various persons listed in subsections A through Z? They're all persons.
That's true. They are all persons.
Why should we read the word persons to mean more than a list of different types of persons?
It's just looking at the plain language. It is a broader word. I think we could have said professions required to report. So I would like to just reiterate that our position is that the court doesn't need to decide whether the mandatory reporting statute applied in this case. Even today, during argument, the appellant admitted that the conduct could be unethical independent of the statute. The mandatory reporting statute speaks to the value that the state of Colorado places on protecting children, but even if the mandatory reporting statute did not exist, Ms. Hiotis' conduct, which harmed and endangered children, as found by the ALJ, would still be unethical under the State Board of Education's rule defining unethical conduct.
Should Miotis have lost her right to teach if her then husband, if her ex-husband had threatened to kill her if she reported the abuse of her child?
That would have been a factor for consideration in whether the conduct was immoral. In this case, we've got factual findings from the ALJ about whether her conduct violated the morals of the community. And in this particular case, since we aren't in a criminal proceeding, Ms. Hiotis' state of mind isn't directly relevant. Her misconduct was unethical regardless of her state of mind. We're not here for the primary purpose of punishing her. We're here for the primary purpose of public protection. But if there was a threat to kill an individual, I think that would go to the weight of whether her conduct actually offended the morals of the community. That would be a mitigating factor.
Counsel, I see that you're out of time.
Oh, thank you.
Thank you, counsel, for your excellent arguments. The case will stand submitted and a written opinion will issue in due course. The court will take a short recess. County. Council are now present. You should have been provided with a handout of our procedures. Is that correct?
Yes, Your Honor.
All right. If anyone in the courtroom has a cell phone, please make sure it's turned off, and let's get started.
Good afternoon, Your Honors. May it please the court. My name is David Chipman. I represent the 10 plaintiffs in this action, all of whom are homeowners within the Gun Barrel Public Improvement District in Boulder County. Let me start by talking about what is not disputed in this case, because I think it's important. There are sound policies behind Rule 12b1's standing requirements in the political context. These policies protect against our courts invading legislative and executive decisions just because a voter is disgruntled or upset about something the government does. Those policies are sound. And that is why, in order to show an injury in fact under Rule 12b1, the plaintiff's alleged harm cannot be indirect or incidental to the government's conduct. The plaintiff can't just be an angry voter. He must show a concrete controversy with the government that sets the plaintiff apart from the public at large. In this case, we'll be talking about an enforceable contractual promise made by the government to the plaintiff.
Let's talk about that, because I believe that, you know, you set it up as kind of like a unilateral contract. Here's a promise that was accepted by the action of the voters in the district. Is that correct?
Yes and no, Your Honor.
Well,
Let me address your question. What we're talking about today is an affirmative promise, an affirmative action carried out by Boulder County. They affirmatively reached out to the GPID residents.
Yes, there was a promise made to somebody, and was it accepted, or did it induce some type of action?
Absolutely.
What did it induce?
It induced the passage of the ballot initiative.
Did these voters vote to pass that initiative?
They did.
It's not in the
Well,
complaint.
it's
is it,
not in the
counsel?
complaint, Your Honor. It is, but it is implied and inferred in the complaint.
How is it implied and inferred in the complaint? The trial court even made some comment about it, and I didn't see it addressed in your opening brief, the court's comment.
Well, Your Honor, we have to rely on the complaint that's there, and we did address it in the reply brief. It is inferred that they voted in favor of this. This is not Rule 9b where we have to plead with particularity.
But some of the plaintiffs couldn't have voted because they didn't acquire property in the subdivision until after 1993.
You're right, Your Honor, but they did, some of those voters, all of them succeeded to the rights of their predecessors.
Are we to infer that the predecessors voted for this act?
Yes, Your Honor, and if Your Honor, if the issue is, if the only thing holding up this issue is whether or not the complaint specifically states that these voters voted in favor of the initiative, then we would request an opportunity to amend our complaint. If that's the only issue that's separating us from getting past Rule B5 and Rule B12.1, we would request opportunity to do that,
Well,
because we can absolutely correct that problem.
Well, let me ask you a question about that, counsel. Didn't the court identify that as a standing problem, and did you request an opportunity to amend your complaint after that?
We did not, because we felt the court had dismissed the action and that the next response needed to be an appeal.
And so let me ask you, are we in a different position now that somewhat later you want to ask for an opportunity to amend the complaint? It's no different than after the court dismissed the complaint, is it?
It is not, although we are here arguing and discussing this matter with the court before the court makes its decision. And so at the time, that issue had not been raised by any party, and had we had the opportunity in front of the trial court to make that request, we absolutely would have done so.
And let me ask you, counsel, are you familiar with anybody or the practice of making a motion to amend the complaint after a case has been dismissed? Have you ever seen it?
I have never carried that practice out
Okay.
in 25 years, Your Honor, but I have certainly requested those sort of things before a
Okay.
court enters a ruling, and that's why I believe this is different than it would be in front of the trial court, because the trial court didn't have an oral argument. The trial court just issued its ruling on the briefs.
Can I ask you this last question, then I'll let you get back to your argument, I
Okay.
promise.
Sure.
Did you actually brief that part of the trial court's order that said, you know, this is a problem of standing? You didn't even show you were a voter, much less you voted in favor of it. Did you brief that in your opening brief?
No, Your Honor, we briefed that on a reply brief. The reason we didn't brief it in the opening brief is because, as I stated earlier, it's my belief that in a plausibility issue with notice pleading, even under the plausibility standard, you don't have, certain facts can be inferred and by the fact that we're bringing the complaint in the first place.
Is there any indication in the record that the plaintiffs were voters and voted in favor of this measure in 1993? Anywhere in the record?
In a Rule 12b-5 scenario, we don't get an opportunity in the record to do that in front of the trial court. And we address the issue of the fact that these voters were succeeded to, I guess we addressed your issue, Your Honor, prior to that. So I guess the point I'm making is if we get to that point where the judge's question is, well, gee, they didn't say in their complaint that these voters voted in favor of this. Had they done so, we would have allowed this to get by, but because they didn't, I'm not going to allow this to get by. Well, then that's the time when we should be granted an opportunity to amend our complaint to correct something that we believe is clearly inferred by the fact that they brought the complaint in the first place.
Counsel, if it's not stated in the complaint, how do we infer it? And let me ask you, is there any law on the extent to which you can infer things that are unsaid in a complaint?
Well, it's my understanding of Rule 12b-5, Your Honor, where facts are interpreted in favor of the plaintiff in a Rule 12b-5 context, and not every fact is required to be pled with particularity in a Rule 12b-5 context. And yes, that trial courts and appellate courts will indeed all infer facts based on the facts actually pled in favor of the plaintiff. That's Rule 12b-5 jurisprudence.
In response to the motion to dismiss, did you request leave to amend?
We did not. That issue was not raised as, I don't have a photographic memory, Your Honor, but my recollection is that issue was not raised by the county in their response, in their briefs. But I honestly do not have a photographic memory about that issue.
I will now be quiet. Thank you.
Okay, that's fine. I'm here to answer your questions.
Thank you.
So we've talked about the injury in fact requirement, how that's really important. We get that. And it leads us to another important policy, and that is that statements of principle and aspirational intent in the political realm are not legally actionable. We understand that too. There's important policies behind that. If a voter could sue every time, America was not made great again, or every time somebody makes some promise or some aspirational statement in an election, whether it be a governmental entity or whether it is an individual politician, the floodgates would open and we'd have a major problem. Give you an example. The Berg case that they cited. Use technology to make government more transparent. That's one. Or to provide America's taxpayers top quality service. That's in the Mineham case. Those are political statements. That's not what we're here about today. It makes sense that to allow a case like this to get past Rule 12b-5 is a careful exercise. But Your Honor, Your Honors, what we propose is that it is the duty of a court to engage in that exercise when a case comes along that is different. And that's this case. This isn't Wibby. This isn't the Hickenlooper case. This isn't the Berg case or the Mineham case or the Colorado Springs Fire Department case. This is a completely different animal. And I'll point out something else. There are important sound policies on this other side too. We live in a tripartite governmental society. The courts have an obligation to step forward and place a check on the government when that government makes contractual promises that are enforceable to specific members of the public.
How many people voted in the 1993 election that we're talking about?
Your Honor, I do not know. There are 10,000 residents of the GPID, approximately. That is in the record.
And how many voted in favor of this measure?
I do not know that either. I do know that it passed. And I do know that the government made a affirmative promise to the GPID residents that they would do something very specific, not some aspirational issue. They promised that if the GPID residents passed the Open Space Initiative and the Road Initiative, that they would match up to $1.9 million that increased tax for purchase of open space.
And we don't know whether all the voters, other than your clients, relied on those representations, assuming there were even representations, in voting for the measure.
Your Honor, I would propose that one plaintiff who relied on that representation for voting on this measure would be sufficient, because the promise was specific. The promise was, this isn't Wibby, this isn't Hickenlooper. One problem that people face with these, that we've seen in this case, is that people like to carve out these labels and just slap it on this case as if it's something just like the others. And I would propose, Your Honor, that we can't do that. The way to distinguish this case from those is to compare their facts. And I would encourage the court to do that. We've tried to do that in our briefs. But you have to compare the facts with Hickenlooper and Wibby and the Colorado Springs case. This is an entirely different animal. Now, one of those cases involved a situation where the government affirmatively reached out to specific citizens and made a specific promise to those citizens that if those citizens voted a ballot measure in, the government would match their contribution dollar for dollar up to $1.9 million. If this wasn't the government, that promise, we wouldn't even be here.
And the promise was to benefit the district directly and only indirectly the voters, assuming there was a promise, right?
Correct.
So wouldn't the proper plaintiff in this case be the Gun Barrel Public Improvement District?
No, because the voters are the ones who submitted, who acted in reliance on the government's promise to do the matching.
To benefit a third party.
To benefit the voters and to benefit the government. There's mutual consideration here. The government, with these increased taxes, now doesn't have quite the burden that they thought they had to fix these roads and acquire open space. It benefited the voters because the government promised them a $1.9 million matching, right? So it benefited both the voters and it benefited the government. Your Honors, I will reserve the rest of my time for rebuttal. I have about 2 minutes.
Good afternoon, Your Honors. David Hughes, Deputy County Attorney, registration number 24425, representing the appellees, the Board of County Commissioners of Boulder County, and the Boulder County Housing Authority. I'd first like to address the issue that came up in argument about whether the county raised the issue of the plaintiffs voting in the election. At record CF 46 in the county's motion to dismiss, footnote 4, the county stated, notably, none of the taxpayers affirmatively alleged that they voted in favor of the Open Space Initiative, that the Open Space Initiative would not have passed without their votes, or even that the Open Space Initiative would not have passed absent the challenged campaign promises. Further, plaintiffs Reckberger, Krebs, Reg, Sherwood, and Sherwood acquired their property after the initiative passed, and therefore it is unlikely they voted on the issue at all. So I think that does answer the question of whether the county raised the issue and gave the appellants the opportunity to respond. The other issue that arose in argument that I'd like to address is this idea that was raised both in argument and in reply that the county hasn't previously had the chance to address, and that is this idea that the county received a benefit of money savings by supporting the open space initiative. An open space is not a revenue saving proposition for a county, no matter how you structure it, and there's a couple of reasons for that. First of all, when a property is dedicated as open space, it's not taxable. In most cases, there's no property tax revenue deriving from that property. Second of all, the whole purpose of open space is to prevent development. If development occurs on property, then in addition to property taxes, the county can receive income from sales taxes, for example. So if the county's goal here was to make money, the county, instead of going out and assisting the district with buying open space, they would have upzoned these properties. It could have upzoned them to commercial or industrial. It could have subdivided them into small lots. There's lots of ways local governments can make money by upzoning. Another reason why this isn't a revenue plus proposition for the county is that the concern at the time, and when this vote took place in 1993, was that the city of Boulder was going to annex these properties and develop them, so increase density in the area. So if annexation occurred, then the costs of infrastructure would have been absorbed by the developers or the city of Boulder, not the county. So I just wanted to clarify those two particular issues. So if
Did the county make a promise?
the individual commissioners made a campaign promise, and I think they intended to keep that promise.
When you say the individual commissioners, did they speak in their individual capacity, or did they speak as the board?
It's unclear from the complaint. So what the complaint points to is the notice of election, and the notice of election lists statements in favor and statements against the initiative. The statement in favor of the initiative said the Board of County Commissioners has indicated that. It's unclear to me what context that indication took place. There's no indication that the county commissioners actually voted or passed a resolution that that would indicate an official action of the county commissioners. So this case.
What about the other representations in the complaint?
So there's a representation that during the course of a hearing, it stated on the election that a commissioner made a statement saying that they would, that they think it would make sense to provide half of the funding. So to me, that's a statement of an individual commissioner. There's also a reference to campaign literature. To me, if you look at the exhibit that the complaint references, that's a statement made by the campaign in favor of the initiative, not the commissioners. So to me, that statement wouldn't be relevant at all.
And what is that a certain exhibit in the record, counsel?
Yes.
That certain exhibit?
Yeah, I have that exhibit number. That's Exhibit 4 to the complaint, which is at CF 31 in the record. And since I've turned to it, just more specifically, at the bottom of Exhibit 4, it says, Gun Barrel Neighborhood Alliance, authors of the Gun Barrel Open Space Ballot Petition Initiative, and Scott Dixon, author of this article, recommend you support all three ballot options. I don't know who Scott Dixon is. I don't believe he was a county commissioner, so I don't believe Exhibit 4 could be used to support that the county commissioners made a specific promise.
Is that the same document that states that the Gun Barrel residents will directly see the benefits in open space purchased within Gun Barrel to the tune of about $1.9 million? And that's cited in paragraph 43 of the complaint.
There is, I don't know if that's the same document. There is a reference to $1.9 million at the top of the first paragraph in Exhibit 4, but it's not the exact same language.
Did the county pay for any of the campaign materials in 1993?
The county would not have, under the Fair Campaign Practices Act, the county does not have the ability, except for minor expenses up to $50, to pay for campaign materials.
Do we know who paid for the materials?
I don't know. So, even assuming that the complaint could be amended and there could be an indication that there was a plaintiff out there who affirmatively voted on the initiative based on the particular representation in the notice of election, that wouldn't help the plaintiff's cause. If there could be a claim arising out of a statement or promise made in the course of a campaign, then with all of the elections and all of the voters and all of the ballot initiatives across the country over many, many years, there would be a court that would recognize such a claim. There isn't, because that's not how our democracy works. These issues are public policy issues, and public policy issues are decided at the ballot box, not in the courtroom. District Court correctly dismissed this case in part because of the serious separation of powers issues raised by this case. The taxpayers are asking a judge, not elected officials, to make decisions about the expenditure of hundreds of thousands of taxpayer dollars and value judgments about affordable housing versus open space. As was referred to in prior argument, claims can't be made based on a disgruntled voter. There needs to be a connection aside from the general public being upset with the government. And the only connection that the taxpayers can point to in this case is their vote on, or the vote, I should say, on the GPID initiative.
In response to a certain types of representations.
I'm sorry, Your Honor?
In response to certain representations.
That is the allegation, that the vote was in response to the allegations in the, or to statements in the notice of election. But the only thing that actually affirmatively connects the plaintiff and makes them separate from the general public is the GPID initiative and the fact that there was a vote on this initiative. Initiatives are legislative matters. The placement of ballot issues on the placement of issues on the ballot are legislative matters. And therefore, the only logical context to analyze this type of claim is a legislative contract claim. And the way that legislative contract claims are analyzed is to look at the actual legislation and determine whether there's actual language of contract, whether there's a clear and unequivocal intent to contract.
Are you saying that a legislature is incapable of contracting outside of its legislation?
I think the Board of County Commissioners is certainly capable of contracting outside of the legislation. What I'm saying here is that the only thing that separates the plaintiff's claims in this case from a complaint against the general government is the vote. And you can't look at the vote in a vacuum. The vote was on the initiative, and therefore it only makes sense to look at the language of the initiative to determine what the taxpayers voted for. And if you look at the initiative, there's no contract language, there's no clear intent to contract, but more importantly, there's no indication that the county is going to spend money outside of the GPID dollars raised to purchase open space in the Gun Barrel General Improvement District. The county did, in fact, spend $1.3 million, and the county has indicated to the taxpayers and others that it may end up spending more when the appropriate open space becomes available. So the political promise that has been made has been fulfilled, or at least is in the process of still being fulfilled.
We don't know that, though, from the allegations in the complaint, do we?
We do.
That it's still in the process of being fulfilled?
Yes, I would turn to Exhibit 5 of the complaint, and that's in the record at CF 32. This is a letter that's referred to by the taxpayers that came up more recently, November 4th, 2016, in response to requests by one of the plaintiffs. And the real estate division manager of the county, in the last paragraph of the letter, stated, while it is inaccurate to say that the county has a remaining obligation to invest additional matching funds, it is possible the county might invest additional funds to acquire open space properties within the GPID's targeted area. If the county were to do so, it would likely invest in the remaining priority properties identified by the GIPD Steering Committee. So, you know, the fundamental dispute that's underlying this case is there is this one particular piece of property that the taxpayers want the county to buy, and the county has not identified that as a property that meets the needs and goals of the open space program. It's not that the county has suddenly said, no, we're never going to buy open space in this area again. It's just that the county has said, this property, this particular 10-acre property, is not a piece of property that the county is going to buy. So if you look at the language in the ballot initiative, there's nothing to indicate that there is a contract. And looking outside of the ballot initiative is essentially looking at extrinsic evidence in the context of ballot interpretation, in the context of, Judge Daly, it looks like you want to ask me a question.
I do want to ask you a question. No one's trying to interpret the ballot initiative with this use of what you call the extrinsic, evidence. What they're saying is, what you call the extrinsic evidence is the promise made by the county inducing the other side to do something which requires the promise to be enforced. So there is a different way than considering it extrinsic to the initiative. No one's arguing about what the initiative says. There's no ambiguity in the initiative. The question is there a contract apart from the initiative?
And there's a number of problems with that. The main problem with that is that the taxpayers did not vote on campaign promises. They did not vote on individual statements of the commissioners, and they did not vote on the notice of election. So to bootstrap the vote on the initiative and apply that to statements outside of the initiative is bad policy. And it's bad policy for a number of reasons, the largest one being this issue of a flood of litigation. We have the potential of going back and looking at the elections for the last 25 years, taking a look at the pros and cons with respect to each ballot issue, and deciding whether each statement is specific enough to enforce as a contract. The court shouldn't adopt that as a matter of law or as a matter of policy. I see I am just about out of time. I am out of time. Thank you.
Quickly working from backwards to forwards on some of the things that council indicated. The county, the reason we're here is the county says there is no obligation, that they did not enter into a contract either expressly or through promissory estoppel. Obviously, that's why we're here, because the county says there's no contract. There is a controversy. The legislative contract claim arguments, I think, Judge Daly, you understand our position in that regard. And there is clear and unequivocal intent to contract. I mean, the complaint is full of allegations about this intent. And
Of
if it's
those
not
statements, of the statements that constitute the terms of the alleged contract, how many were made by the county itself?
We allege all of them, and that's the point. We're at a 12B5 stage, Your Honor, whether they spoke as individuals or as the county, whether the county made the representations or not, whether the county paid for materials, whether the county benefited from this, whether there is no other property available. Those are all factual issues to be decided by the trial court. That's not why we're here today. Those are all weighing evidence and deciding those things. That's something that comes later, not now. I'm running out of time quickly, but I want to address this issue of whether the voters allege they voted. You know, it's been a long time since I prepared the motion to dismiss. I will say this. Rule 12B5 is not a gotcha rule, particularly when you don't have to plead with particularity. If the trial court had identified only this issue of whether we had alleged that the voters had actually voted in favor of this, that's a different story. But the trial court covered many other different issues, and we are covering those issues. I again request, Your Honor, that if that's the only thing dividing this from a Rule 12B5, that we be granted the opportunity to simply amend the complaint and fix that problem. Thank you, Your Honors.
All right. Thank you, counsel, for your excellent arguments. The case will stand submitted, and a written opinion will issue in due course. That concludes the arguments for this docket.